discuss the nature of administrative law. Administrative law is a branch of public law that regulates the powers, functions, duties, and control of administrative authorities. It governs the relationship between the state and individuals and ensures that governmental powers are exercised according to law. Unlike many traditional branches of law, administrative law is continuously evolving to meet the changing needs of society and the expanding functions of government. The nature of administrative law can be understood from its public law character, its close relationship with government administration, its dynamic nature, and its development through judicial decisions. Legal provision. Administrative law is not codified in a single enactment. Its principles are derived from Article 14, 19, 21, 32, and 226 of the Constitution of India. Principles of natural justice, delegated legislation, administrative adjudication, judicial review, various statutes governing administrative authorities. These sources collectively form the foundation of administrative law. Essential features or contents. The nature of administrative law may be understood through the following characteristics. It is a branch of public law. It is closely connected with government administration. It is dynamic and continuously developing. It is largely judge made in character. It seeks to balance administrative efficiency with protection of individual rights. Public law character. Administrative law is essentially a branch of public law because it deals with the relationship between the state and its citizens. Unlike private law, which regulates relations between individuals, administrative law governs the exercise of public power by governmental authorities. The primary concern of administrative law is to ensure that public authorities act within the limits prescribed by law. It regulates governmental functions, administrative discretion, and public duties while protecting citizens from arbitrary actions. Thus, its focus is on public interest, public administration, and governmental accountability. Because administrative authorities exercise powers on behalf of the state, their action must conform to constitutional principles, statutory provisions, and the requirements of fairness and reasonableness. Relationship with government administration. Administrative law is closely connected with the machinery of government administration. It provides the legal framework within which administrative authorities perform their functions. Modern governments are required to undertake numerous activities relating to education, public health, social welfare, environmental protection, taxation, labor welfare, economic regulation, and public services. These functions are carried out through various administrative departments, boards, commissions, and regulatory authorities. Administrative law defines the powers of administrative authorities, the procedures they must follow, the limits within which they must act, and the remedies available against misuse of power. Therefore, administrative law is often described as the law governing administration. Without administrative law, governmental administration would lack legal control and accountability. Dynamic and developing branch of law. One of the most important characteristics of administrative law is its dynamic nature. It is not static but continuously develops in response to changing social, economic, political, and technological conditions. The growth of the welfare state has significantly expanded governmental functions as new administrative challenges emerge, new legal principles and regulatory mechanisms are developed to address them. Administrative law adapts itself to modern requirements such as environmental governance, digital administration, consumer protection, data regulation, and public accountability. Unlike many traditional legal subjects, administrative law is constantly evolving evolving because administrative functions themselves are continuously expanding. This adaptability makes it one of the fastest growing branches of modern law. Judge made nature of administrative law. Administrative law is largely regarded as a judge made law. Many of its fundamental principles have been developed through judicial decisions rather than legislative enactments. Concepts such as natural justice, legitimate expectation, proportionality, reasonableness, fair procedure, and judicial review have largely evolved through judicial interpretation. Courts play a crucial role in controlling administrative authorities and ensuring that they act lawfully. Through their decisions, courts have established standards for administrative fairness and accountability. Judicial precedents have therefore become an important source of administrative law and continue to shape its development. Importance or significance. The nature of administrative law reflects its vital role in modern governance. It ensures that administrative authorities exercise their powers, responsibility, and within legal limits. By controlling administrative discretion and protecting individual rights, administrative law promotes accountability, transparency, fairness, and the rule of law. Its dynamic and judge-made character enables it to adapt effectively to the changing needs of society. Conclusion. Administrative law is a branch of public law that governs the functioning of administrative authorities and regulates the relationship between citizens and the state. Its close connection with government administration, dynamic nature, and development through judicial decisions make it a unique and indispensable branch of modern law. As governmental functions continue to expand, the importance of administrative law will continue to grow in ensuring lawful, fair, and accountable administration.